going to be talking about preliminary hearings, so here we are. So what's a preliminary hearing? A preliminary hearing is a hearing that is done in felony cases that is essentially a probable cause hearing. It's to determine whether or not the prosecution, now keep in mind, the state has the burden of proof, not the defense. It's a hearing that forces the prosecution to try to establish that they have enough to go forward. Now, this is important. This is a due process right. The idea is that you're not supposed to be arrested and charged just willy-nilly. There has to be a stage at which the government has to be able to go forward based upon some kind of evidence. Now, the standard of preliminary hearing is different than what you have at a full trial. In trial, the standard of proof is beyond reasonable doubt. That is those standards which means the highest standard we have in our criminal justice system. People have to be convinced more than just a little bit. But a probable cause hearing is different. At a preliminary hearing, a judge can be satisfied with some of the evidence that barely gets over the bar, if you will. In fact, numerous judges will tell prosecutors, you got enough to be able to go forward, but I don't know if you're going to have enough at trial. So what happens at a preliminary hearing? Well, there are witnesses that testify. Now, under the law, police officers can't really testify on what was told to them generally, in a trial, that is. At a preliminary hearing here in California, they are able to do that. They have that ability. So, part of the question would be, what's the good of a preliminary hearing if you don't get to see all the witnesses? Well, one, sometimes you will get to see some witnesses. There could be reasons why the prosecutor would put a witness on. Let's say it's a witness who they think may be reticent, or a witness who they think may be unhealthy. They would want to get that testimony under oath and recorded with a transcript as quickly as possible. This also, because they would be subject to cross-examination, the witnesses that is, it means that that testimony would be admissible at trial. Now, for the defense, why would you want a preliminary hearing if it's just going to be the cops talking? Well, you want it for a variety of reasons. One is, it's your first chance to see what exactly the prosecution has. Now, we should emphasize the prosecution doesn't have to give you all the discovery at this point. But if you have asked for any exculpatory information, the prosecution has it before prelim, but doesn't give it to you before prelim, then gives it to you after the prelim, or you find out that they had it after the prelim, well, that could be grounds for dismissal. The other reason you want to have a preliminary hearing is you can get charges reduced or dismissed. We've been able to do that on numerous occasions. That's not a guarantee it happens to everybody, but it could be done. So in a nutshell, that's how preliminary hearings work. Now, there are other ways of indicting people via grand jury, and we can talk about that another time.
It's always an honor to be back at my favorite position, teaching about the law. Never mind my backdrop. I'm at the Cash Kid Center where we do everything. We do research on the computers. We play games. We do a whole lot of everything in here. But today we're going to be talking about what my free attorney was talking about. Now, in a preliminary hearing, you should never want to waive that. Take it from me, I fought like hell to try to get a preliminary hearing, and it wasn't happening on any stages, right? Because the prosecutor and the judge was in cahoots. When you got a situation like that, it's very important to be up on your public defender or your hired attorney who's representing you. Most attorneys will tell you if it's in your best interest to supposedly waive away that right. But I do not recommend waiving away your preliminary hearing rights. You want the prosecutor to bring forth his evidence. And I'll go over the paperwork because you know I'm all about bringing up the paperwork. I like to have paperwork. Let me see if I could. Thought I was going to have. I want to extend it like that because I want to. So the reason why I told myself that I will get back into this is because there's sometimes situations occur and people just don't want to call you and ask for your help, but if they see you really involved in it and they can actually read along with you, then they know that you're not playing, right? So what I did is actually went and got some help from a free attorney. who explained what a preliminary hearing is, but you did hear that he was in California. And California and Oregon is about the same. Their laws are applied in the same matter, except we don't have a three strike you're out. We have a one strike you're out rule called Measure 11, and that falls under what's called the mandatory sentence. So that's why I say it's very important for people to understand their rights to a preliminary hearing, and we will read some of this stuff right in here. In any felony cases, an arrest or a criminal complaint is not enough to require the defendant to stand trial for a crime. Shortly after arraignment, the court must conduct a proceeding, a preliminary hearing, or a grand jury proceeding. Now, here in Oregon, you are allowed to have a preliminary hearing, and that's how I learned it through my case, because on my court audio transcripts, you hear certain individuals stating that I waived away my right to a preliminary hearing. And I always told these people, no, I never waived away my preliminary hearing rights, and you shouldn't waive away your preliminary hearing rights either, right? Where the state is required to present enough evidence to establish probable cause to believe that the defendant committed the crime. The defendant cannot be required to stand trial unless the prosecutor can present significant evidence to charge the defendant with a felony. And then we'll get into more of the information. And a lot of public defenders look at the defendant as if they are ignorant, like they don't understand what's going on. And that's why we have to be strong enough to help each other get through these stages. And yeah, we're not going to be there when somebody actually commit a crime and be able to say, hey, ask for your preliminary hearing. So what we have to do is train that person. If that person know that they in a lower poverty area and they struggling and real is real, and sometimes they have to step outside of the box and take some type of risk, then you better beware of what happens during a preliminary hearing, right? So here, a preliminary hearing, a judge hears the state's evidence and decide whether there is significant evidence to require that the defendant stand trial. The defense is not required to present evidence, meaning you are not. Only the prosecutor. The defense is you if you standing up against these felony charges that the prosecutor is trying to get this judge to indict you on, right? So the defense is not required to present evidence, but may choose to do so to rebut the allegations against the defendant. If the evidence is not significant to establish probable cause, the judge must dismiss the charges. And a lot of these judges that I've went up against, at least in Salem, Marion County, are cricket. They don't follow the rules. They do things in their own, by their own book. So even though this is the law, don't mean that these judges and prosecutors and public defenders and private attorneys and so forth is following the rules. So even though I'm reading this to you and you try to hold these people accountable for not doing their job, they still gonna blow you off. So, but it's good to know the information, right? Some states use grand jury proceedings. That's what you heard from the free attorney that I got up here, and we gonna play his video back again once I'm done. Some states use grand jury proceedings as an alternative to the preliminary hearing. The prosecutor present evidence to a grand jury made up of members of the public. No judge is present, but the grand jury is instructed to review the evidence according to the probable cause standard and determine whether there's significant evidence. If the grand jury finds probable cause that the state issued an indictment against the defendant, and he must stand trial for the charges. When does a preliminary hearing occur? Now, this is a very, very important part of this, and I'm gonna try to get this up. So, try to get this up. So. I did that. I did that totally wrong. Sorry, guys. I gotta minimize this so I can bring it up just a little bit. Just a little bit. Okay. That. When does a preliminary hearing happen? We want to get this big enough for you guys to see it. If a defendant is arrested and held in custody, a preliminary hearing, let me use this. If a defendant is arrested and held in custody, a preliminary hearing must occur within a certain number of days or the defendant must be released from custody. The United States Constitution and the state constitution, as well as criminal rules of procedures for the state courts, provide that the defendant can be held for only a limited time on the basis of an arrest and criminal complaint. In order for the courts to continue holding a felony defendant in custody, the courts must conduct a preliminary hearing within the amount of time prescribed by the state law as issue a formal charging instrument, sometimes referred as a criminal information. If the preliminary hearing is not conducted within the time prescribed, and the defendant must be released. If the defendant has been released on bail or on recognizance, the courts can conduct a preliminary hearing at a later time. However, the preliminary hearing must occur within a reasonable time of an arrest. An unreasonable delay violates the defendant's federal constitutional. We'll get into that here. I gotta blow everything up for us to see. Federal constitutional amendment right to fast and speedy trial. If the defendant is arrested on charges in a criminal complaint and the prosecutor's office or the court does not schedule a preliminary hearing until months or years later, the case can be dismissed because of the delay. The judge must review the circumstances of the delay and determine whether the delay was unreasonable, therefore violates the defendant's constitutional rights to a fast and speedy trial. Now, back in the days, you heard me arguing with Susan Tripp about this, right? And she said, can we just get off the preliminary hearing? It just shows you proof that she didn't care about my preliminary hearing rights. Me as a defendant didn't have those preliminary hearing rights because they already made up this so-called story that I waived away the right to have a preliminary hearing right. But see, I knew the evidence. I knew the law. I knew how to research, and I knew how to keep my foot down. And I'm like saying no. So, and that's the reason why I'm under appeal today. So what happens at a preliminary hearing? All this matters when you think about what take place at a preliminary hearing. A preliminary hearing, somewhat like a mini trial. You hear what they said. A preliminary hearing is something like a mini trial. The prosecutor can call witnesses to testify and present physical evidence or documents and record evidence to show that the defendant likely committed a crime. A preliminary hearing usually is not as exhaustive as a criminal trial, right? And the prosecution likely will not present all its evidence against the defendant, just enough to establish probable cause. the rules regarding what kind of evidence can be presented may be more relaxed than at trial. For instance, hearsay may be permitted. And when they talk about hearsay may be permitted, this hearsay is coming directly from the cops that investigated you initially. And this is what I learned in me going through my situation. So I can't necessarily talk about what everybody else's situation is, but I can give enough information to understand how they work and operate in the judicial system. Like I said, the rules regarding what kind of evidence can be presented may be more relaxed. And this is why I say the prosecutor got broad discretion, because the prosecutor normally know that in a preliminary hearing setting that the rules are more relaxed. It's not like a real go hard or go home trial. So they can put on enough lies to get the indictment to move forward, to get you to forcefully take a plea offer, because that's the objective here in dealing with the courts anyway, is that they want you to take a plea offer so they can and have you trapped, have you enslaved into their system under their jurisdiction. When you are a private citizen and they don't have jurisdiction over your life, then they can't really control you, sort of kind of thing, right? So it's good to hear this and read some of this stuff. And most of us don't take the time to read this stuff because we rely on the public defender to do their job. And like I explained to people time and time again, you don't have an attorney when they are called public defenders. The public defender's job is to defend the public. That's why they are called public defenders. And if you committed a crime in the public, towards the public, then they have a total bias on how they're going to represent you. So you got to be aware of asking these type of questions under your attorney-client privilege, is to explain the process, explain how what it means to violate due process to a fast and speedy trial. Most of us just sit on it. We don't ask for this preliminary hearing, right? Because we know that the prosecutor is going in with relaxed rules. For instance, hearsay may be permitted. This means that a police officer can testify about what a witness told him during interviews, and the prosecutor will not be required to have those witnesses testify at the hearing. How courts conduct preliminary hearings and what occurs in each hearing varies with each state law and its state's constitution, right? And if you got a prosecutor that's been on the bar, that's been doing things for the community for many years, 22, 23 plus years, those whole 23 years hasn't always been bad, you know. And the thing is, you start off good, but when you get relaxed and you want power and fame and you want to be the top dog and you don't want to do things the correct way, that's what happened. That's exactly what happened. So rights to counsel at a preliminary hearing. So my grandma once told me, you haven't, if you haven't read or highlighted through anything, then you ain't read nothing, right? So when you see the pink highlights, this is pertaining to me back in 2014 when I was going through my case and I was actually fighting to have exactly what I'm explaining today. Thank God that I'm not in any criminal trouble right now to where I got to go back and forth through court. So if you got court, this is some stuff that you should be passing on and that you should be sharing with people. And take it from me and my free attorney, because I like to find free attorneys, the ones that don't charge you a consultation just to tell you something that you just looking for answer to, that you already know is correctly sound, right? They call that you looking for confirmation, right? So that's what I do. I do a lot of research on that. So, right, a defendant is entitled to have an attorney represent him at a preliminary hearing. The defendant requests the attorney. The courts can. This is a very important part right here. If the defendant requests an attorney, the courts cannot, right? They cannot conduct a hearing without assuring that the defendant have private counsel or appointing an attorney such as a public defender to represent the defendant. The defense attorney can advise the defendant of his rights, make arguments to the court about whether the evidence is significant to support a formal charge against the defendant, and present evidence on behalf of the defendant. And this did not happen in my case. In my case, the so-called public defender, Carrie Weiland, said that me and her came up with this agreement to waive away the preliminary hearing. Should the defense present evidence at a preliminary hearing, and should the defendant testify? Now, under your Fifth Amendment right to the United States Constitution, I don't care what state you in, you do not have to testify. When you do, and I want to talk about why it's very important not to get on the stand to testify. And they use me as a puppet to teach me this, right? That if you get up on the stand and testify, now they can bring up everything in your past. They can bring up, the jury get to hear, but that's if you got a grand jury and you on trial. You do not want to take the stand if you in trial and you have a grand jury of your peers, because then the prosecutor gets to bring up things that has no merit to your case to make you look bad enough for a criminal to be charged for the crimes that he or she is trying to legitimately prosecute you on. Yeah, prosecute you on. So when we talk about should you testify, take it from me, I say no go. Because the way, and I got a lot of evidence to back up my claims on why it's very important to know about your preliminary hearing rights. After I explain it, we'll let my free attorney do it too. And you know what's so funny is when I think about it, this man is sipping alcohol while he's been an ex-prosecutor, and now he's representing, giving good advice to those who want to. Rather to present evidence, and rather the defendant shouldn't testify at a preliminary hearing, are questions that the defendant and his attorney must answer in each individual case. In some cases, it may be best for the defense to simply let the prosecutor present its evidence and say very little. In other cases, however, there may be compelling evidence. Now, this is where I recommend that you waive away your preliminary hearings if it falls under these guidelines right here. Under there may be compelling evidence that show clearly that the defendant did not commit the crime or was incapable of committing the crime, perhaps because he was out of the country or in another state when the crime was committed. Then the defendant has solid evidence to establish an alibi, right? That's where you waive your preliminary hearing, because you know that you wasn't there. You know you didn't commit the crime. No matter what the prosecutors say, your alibi is 100% good, right? In some cases, the defense attorney and the defendant may agree that the defendant should testify at a preliminary hearing. For instance, in the case may involve the issue of self-defense, and the defendant may be a much more credible witness than the victim. This kind of decision is very difficult to make, and a defendant should never choose to testify at a preliminary hearing without consulting with an attorney or exploring the matter thoroughly. Now, your public defender may not want to give you no good game. They may not give you no game at all. They may tell you, yes, in your best interest to waive away your preliminary hearing, but it's not really in your best interest to ever waive away your preliminary hearing. And you got to force your attorney to understand that you know the significance behind waiving your preliminary hearing, because criminal defendants usually have the option to waive the preliminary hearing. But this happens very rarely, and no defendant should do this without the advice of attorney. If you waive away a preliminary hearing, you allow the prosecutor to proceed on criminal charges against you without having to present its evidence. Now, if you know you didn't commit no crime, right? You know, and you know for a fact that the prosecutor got bull crap on you, you can waive that, like I said earlier in this video, and I don't want to sound contradicting, but in the rules, it says that you're not supposed to waive away your preliminary hearing right if you know you're innocent. Because if you waive away that right, then the DA gets to sit on it and he gets to build a case. If you make him bring forth what he got right now and then your chances of having it dismissed is better than later, right? Like they say, if you waive a preliminary hearing, you allow the prosecutor to proceed on criminal charges against you without having to present its evidence. Most likely, a complete defense attorney would recommend waiving the preliminary hearing only if the evidence against the defendant was substantial or overwhelming, and waiving the preliminary hearing will benefit the defendant in a significant way. What do they mean by waiving away the preliminary hearing will benefit the defendant in a significant way? Is the fact that now you allow the prosecutor to will and deal with you. They get to say, well, here in Oregon, you fall on the mandatory grid. You're looking at 48 to 70 months here, but we will charge you outside of what's called a presumptive sentence, and we'll give you this time to do, right? So they get to do the plea bargain system with you. That's what they mean by it benefiting the defendant in a significant way. For example, if the case is a high-profile matter involving a great deal of publicity, the attorney might recommend waiving preliminary hearing in order to limit the release of information and evidence to the public. And then this is what I talk so importantly about, is the plea before preliminary hearing. If you willing to take a plea bargain and not willing to have the prosecutor in any case present its evidence, then you got a big problem on your hands. Because if you taking the plea, then you basically admitting to guilt on your own admission. And that's what a prosecutor looks for. It makes the prosecutor job easy, right? Because now they don't have to go through fouling motions, and they don't have to write up rebuttal arguments, and they don't have to do any of that. They saying that this defendant know he or she messed up, and they willing to take a plea bargain. As a matter of fact, I'm willing to offer this defendant 36 months probation time, credit for time served, community service, and that's it. You know, pay off fines and restitution. That's what normally happens here. So you got to be very, very careful pleading before a preliminary hearing. If you are arrested and receive notice that you will be charged with a felony, contact the attorney immediately. See, and this is where I say that they violate due process, because that immediately contact an attorney, you don't get no phone call when you get arrested. You have to wait, and you have to go to what your first court date, which is your arraignment, and then you have to fill out paperwork to see if you indigent or not, to be able to afford, because if you can afford an attorney, then the courts want to appoint you one, but they also give you a certain amount of time to retain that attorney. So they work very, very tight when it comes to trying to prosecute, because you're not the only one that's moving through the court. There's several people that's going through misdemeanor charges and felony charges, and it all falls under one judicial branch, and that's the criminal justice, right? So having to know what to do when it comes to a preliminary hearing, I say do your research, learn about it. A knowledgeable attorney can protect your rights and keep you informed through the preliminary hearing process. In addition, in some cases, it's possible to negotiate a plea with the prosecutor before a preliminary hearing. An attorney can investigate this possibility and advise you as to whether it's a good option for you. And like I say, in my case, I fought like hell to try to keep my preliminary hearing rights. That I knew for a fact that this prosecutor Douglas Hanson and this judge and this attorney all was working together. I just had to stand ground. I had to wait and wait and wait and wait, and up until today, it's 2021, and my case started back in 2014, and I'm still currently under appeal for it. I'm praying that the Oregon Supreme Court see my case and send it back to Marion County, because if it does happen, then they in big trouble, and they know that, and that's why a lot of them judges retired and all that. Now, I say this to say, why would Matthew get back into this? I took a long time off of the preliminary hearing, right? I took a long time off of talking about my case, all that, because I want people to understand that, like y'all said, if it happened to me, how many other people is it happening to? But it takes a person like me to go through it to be able to teach about it, to show you. Again, now I just went over the preliminary hearing. I give y'all the free attorney who will also go over it, and I like to give him kudo points, because when somebody is teaching you something and you willing to just learn about it. And there's several of them on here, right? There's several of them, and like I said, this prosecutor sipping.
Good afternoon.
Look how he debriefing for us.
Monday the 12th or 13th, something along those lines.
So you are still allowed to be a human.
I told you we were going to be talking about preliminary hearings, so here we are. So what's a preliminary hearing? A preliminary hearing is a hearing that is done in felony cases that is essentially a probable cause hearing. It's to determine whether or not the prosecution, now keep in mind, the state has the burden of proof, not the defense.
Right.
It's a hearing that forces the prosecution to try to establish that they have enough to go forward. Now, this is important. This is a due process right. The idea is that you're not supposed to be arrested and charged just willy-nilly. There has to be a stage at which the government has to be able to go forward based upon some kind of evidence.
Right.
Now, the standard of preliminary hearing is different than what you have at a full trial. At a trial, the standard of proof is beyond a reasonable doubt.
Beyond.
Those standards, which means the highest standard we have in our criminal justice system.
Okay.
People have to be convinced more than just a little bit.
Just a little.
But a probable cause hearing is different. At a preliminary hearing, a judge can be satisfied with some of the evidence that barely gets over the bar, if you will. In fact, numerous judges will tell prosecutors, you got enough to be able to go forward, but I don't know if you're going to have enough at trial. So what happens at a preliminary hearing? Well,
so I'm going to pause it right here, and I'm gonna bring up the second page of the preliminary hearing where let me see, is it there? No, because he's gonna explain this, and he's a California attorney, right? But the thing is, Oregon is the same. Oregon, Oregon is the same. The law around the preliminary hearing. And what he's talking about is that the judge tells the prosecutor that, yeah, you got enough established that something may possibly happen, but do you have enough at trial to make sure that this case is charged? I just went through this, and here it is. I shouldn't. So what I'm gonna do is try to get it to where he's explaining. He's explaining this for us, right?
There are witnesses that testify. Now, under the law, police officers can't really testify on what was told to them generally in a trial, that is. In a preliminary hearing here in California, they are able to do that. They have that
and they able to do it here in Oregon
too. The question
too.
would be, what's the good of a preliminary hearing if you don't get to see all the witnesses? Well, one, sometimes you will get to see some witnesses. There could be reasons why the prosecutor would put a witness on. Let's say it's a witness who they think may be reticent, or a witness who they think may be unhealthy. They would want to get that testimony under oath and recorded with a transcript as quickly as possible.
Yeah.
There's also, because they would be subject to cross-examination, the witnesses that is, it means that that testimony would be admissible at trial.
Right.
Now, for the defense, why would you want a preliminary hearing if it's just going to be the cops talking? Well, you want it for a variety of reasons.
Come on.
It's your first chance to see what exactly the prosecution
does.
Now, we should emphasize the prosecution doesn't have to give you all the discovery at this point. But if you have asked for any exculpatory information,
everything,
the prosecution
full discovery,
prelim, but doesn't give it to you before prelim, then gives it to you after the prelim, or you find out that they had it after the prelim, well, that could be grounds for dismissal.
Yes, it is.
The other reason you want to have a preliminary hearing is you can get charges reduced or dismissed. We've been able to do that on numerous occasions. That's not a guarantee it happens to everybody, but it could be done. So in a nutshell, that's how preliminary hearings work. Charge just willy-nilly. There has to be a...
So you hear that, and I always like giving other examples of the preliminary hearings, but I look for like short videos, right? But with real lawyers that explain, like this guy right here, he's very knowledgeable about preliminary hearings.
This is evidence to prove.
Hold on.
The prosecutor does this by... A preliminary hearing is a special proceeding where the prosecutor presents its evidence to prove the elements of the crime. The prosecutor does this by putting on witnesses, including a police officer or a detective, to testify against you. And under California Proposition 15, or Prop 15, the cop can testify to statements which the complaining witness made against you without the witness even having to be present in court.
Now, let me stop it right there, because y'all think because he's saying California that it doesn't apply here in Oregon, right? So let's look. The rules regarding what kind of evidence can be presented may be more relaxed than at a trial. For instance, hearsay may be permitted. This means that a police officer can testify about what a witness told him during the interview, and the prosecutor will not be required to have those witnesses testify. Not at the preliminary hearing stage, but when you get in trial, that witness must be called to the stand to testify. It cannot, hearsay is admissible in court when you actually in a real trial. Now, they explaining what happens and what's going on during a preliminary hearing, not an actual trial where your rights are being preserved for other reasoning.
Prosecutor convinces the judge, the court will hold you to answer, and you are then bound over to the felony pretrial phase of your case. That phase begins with a felony arraignment. If the prosecutor does not convince the judge, if your lawyer is able to successfully rebut the evidence or successfully put on an affirmative defense, the court will dismiss your case. Or sometimes a hybrid of the two occurs, where the judge dismisses some of the counts against you, but holds you to answer for others. It is important to note that the prosecutor's burden of proof to hold you to answer is very, very low, particularly when compared with their burden of proof at a jury trial.
Yes.
Unlike a trial, where the government has to prove your guilt beyond a reasonable doubt,
Come on.
the court need only have a strong suspicion of your guilt, which is a minimal standard of proof. The preliminary hearing, however, is a great opportunity for your attorney to test the strengths and weaknesses of the criminal case against you.
That's
It is
if
also
you
an
have an
opportunity
attorney
to seek
willing
to dismiss the case either at the preliminary hearing or even at a subsequent hearing, where your attorney can argue what is called a motion to dismiss.
Yep.
If your lawyer is a skilled legal writer and researcher, he may be able to prevail, even if you lost your preliminary hearing.
So when he talk about motion to dismiss, what we like to do is show evidence, and what I like to do is go into my public defenders folder here, right, and then I go into David Coons, right, and in David Coons' motion to dismiss, we got. Normally I have this in a PDF. I see. No, that's not it. So it's every other one. So it's gonna be every other one. Did he say motion to suppress the evidence? Let's see what he say.
If you lost your preliminary hearing and thus obtain a to dismiss. If your lawyer is a skilled legal writer and researcher, he may be able to prevail, even if you lost your
motion to
either at the preliminary hearing.
Motion to dismiss. Let's see again.
Hearing, or even at a subsequent hearing, where your attorney can argue what is called a motion to dismiss. If your lawyer is a skilled legal writer and researcher,
okay,
he may be
so
able to.
What happens under a motion to dismiss is it could be for lack of venue, it could be for whatever the lawyer is going to federally argue. And I give you an example of what the attorney is talking about here. There's all kind of motions, but I only have one for motion to dismiss, right? We'll get that one. Number 16. So this is a example of what he mean if you got a skilled attorney that will argue that will argue uh, it's called motion to dismiss for lack of proper venue. Now, under this, you'll have the United States constitutional penal codes that support why you want this motion to take place. And this is about having a skilled attorney, just like he say here in his video.
Test the strengths and weaknesses of the criminal case against you. It is also an opportunity to seek to dismiss the case either at the preliminary hearing or even at a subsequent hearing, where your attorney can argue what is called a motion to dismiss. If your lawyer is a skilled legal writer and researcher, he may be able to prevail, even if you lost your preliminary hearing, and thus obtain a dismissal of your charges.
So you hear that? That's good. That's good research and evidence, right? And I will come now the defendant by through his attorney David B. Coon respectfully moved to courts to order and dismissal of count 1 upon the grounds for the reason that proper venue is a matter is not in Marion County. The charges is based on events alleged to have occurred on or about May 16, 2014. The defendant conducted that holding trial in Marion County will violate his constitutional statutory guaranteed rights. Defendant requests an evidentiary hearing, oral arguments of the motion, and I never got none of that, right? So, all this is tied into having a preliminary hearing. You have to have a preliminary hearing if you want to successfully get through a case. I recommend that you have a preliminary hearing. It depends on the amount of evidence is before you, right? Like I say, I do this. This is what I do. I research, and it takes me a while to get stuff going. Y'all check out my YouTube page. If y'all want to know how, just click on my picture right here. Go to my channel. You'll see I'm live right now. Right, and I'm about to end this because there's not too much more that we could talk about as far as the rules of a preliminary hearing. But this is actually how my page look. Go subscribe to me and get full updates of what's coming next. Thank you guys for watching. I will be making more of these videos. I slowly get back into it, working on other things. But I just wanted to reach out and give that little bit of information on the ups and the downs of having a preliminary hearing. If you choose to have a preliminary hearing, make sure that your evidence is accurate, and make sure that you got perfect alibis. Make sure that the public defender or the hired attorney is actually working for you and not against you in an attempt to negotiate your life under the plea bargain system. This has been a wonderful time kicking it with you guys. I'm getting better at not blaming the prosecutor in Salem and all that for his unethical violations. What I will say is that I'm way stronger at putting out the evidence. So if you want help with anything, please reach out to me. Check me out on my Facebook page right here. Y'all see my Facebook page right here. I'm always guaranteed having on that red hat. So anywhere you check me out, you can check me out on my Undercover Corruption page or my Matthew_Johnson Jr. There are so many links that I got and so much information that I have to share. Yeah, be cool, y'all. I'm gonna do a lot I'm gonna let y'all all in on my inbox. All the conversations. I may expose myself. It's gonna be called self-expose. But God bless y'all and have a